Good afternoon, everyone, and thank you all for joining us for today's presentation. My name is Marissa with Legal Aid of North Carolina's Helpline. Today we have Sarah presenting for us. If you are unfamiliar with the format of this event, first, Sarah is going to review a PowerPoint presentation. At the end of the presentation, we will have a question and answer session. If at any point during the presentation you have questions, you can put them in the Q&A box on Zoom or the comments section on Facebook. We'll review all questions put in the chat boxes during the Q&A session at the end. Please remember that this is a public forum and legal aid is not representing you at this time. Sarah will go over this in more detail, but please remember to keep your questions as general as possible, as we cannot provide any legal advice specific to your individual situation. We will not take any more questions after 3:30, and we'll have a hard stop at about 3:45 p.m. With all that being said, I'm going to pass it over to Sarah to get us started.
Okay, thank you so much, guys. Today we are just going to walk through the basic steps of filing for divorce. So this doesn't involve custody or support. This is just strictly the full divorce that makes you legally on your own and independent. We offer quite a few different types of legal services here at Legal Aid. We have a central intake unit that can assess your legal issues. We cover disaster relief, housing, domestic violence, among many other things. And so we will have information on how to get in touch with us if you have questions specifically. Here are all the different areas we cover. We also do veterans legal, consumer issues, Medicare, Medicaid, employment, and education. This is our intake number. It covers the entire state, so you can give this number a call and see if anybody at Legal Aid, depending on which county you are in, could assist you with the legal issues that you are having. Okay. For today's purposes, Legal Aid is not an attorney for you, so we can't get into detail about the particular issues of your case. This is just a generalized overview of the process itself. So we can answer lots of questions about process, but we can't really tell you and answer questions about specific facts. So just keep that in mind. All right, what are we going to cover today? First, we're going to cover whether or not you need to be filing now. There's a few different issues that could impact when you file. And so we're going to go over the reasons why you might want to and why you might not want to. The information you need, we're going to talk a little bit about the forms that need to be completed, how you file these actual forms and get this lawsuit started, and then what happens when you come to court to request the divorce. Is it right for you? First and foremost, one of you needs to have been living in the state of North Carolina for the last 6 months. That's what gives North Carolina the ability to consider the divorce petition that you are filing. So if you are both living out of the state, this is not the state to be filing it in. As long as either you or your spouse is living here and has been living in a county in North Carolina, this is the place to be filing. If your answer is no, obviously you need to wait until one or both of you have lived here for at least that 6-month period. The second and biggest factor that needs to be considered is, have you and your spouse been living separate and apart for an entire year prior to the date you file this lawsuit? This means that you will have to have lived in 2 separate households for 365 nights. And there is not a lot of easily getting around that. Living separate and apart does not mean that you have decided you don't want to be together, but you're living under the same household. That does not qualify you for obtaining a divorce. You must live in separate households, and you must live in those households for a full 365 nights before you come to court to file this. In the event that you end up getting back together, attempt to remain in the marriage, start living together for a week, and then decide that it isn't working, it starts the time over, which is quite frustrating. But this is the number one issue that's going to come up when you are asking for the divorce. You have to be able to tell the judge and sign the complaint that you have in fact not lived together for that 365. As I've said, living in the same house under the same roof in different bedrooms does not count. The next and major issue related to absolute divorce here in North Carolina is how it's going to impact your ability to get things like spousal support and distribution of property. Anything that has to do with the money that you two shared during this marriage cannot be, no suit can be filed if you have already obtained this divorce from a court. If you want to divide property, whether it's a house that you bought when you were in the marriage, whether it's a 401k, whether you're seeking support in the form of alimony or post-separation, you cannot file those lawsuits if you've already received a divorce from the judge. They must be asserted, and those lawsuits must be filed, and at least just filed, at the time that your divorce goes into effect. It does not have an impact on child custody or child support. Both of those things can be filed at any time, married, divorced, anytime. So your right to financial separation is what really is impacted by this divorce. As I said, no child support, no child custody impacted. Okay, so what do you need to file? It's fairly straightforward. There are not a lot of things. You're going to need to be able to give the court your full legal name and your spouse's full legal name. You're going to need to give the court both of your addresses to show, yes, one of us has been living here for 6 months. Here is our North Carolina address. This is why a North Carolina court should decide this. If you have your marriage license, that is important, but it is not mandatory. You're going to need to enter into the complaint your children's full names and birth dates. And your spouse, if they are in active duty military or inactive, you are needing to produce that information to the court as well. The court is going to want to make sure that the defendant isn't overseas or on active duty. They want to make sure that the defendant is able to get to a court date if needed. And so if there is an issue, if they are in the military, the court's going to want to ask a few more questions about it. Other things you'll need: a printer. You are the person that is obligated to print out all of these forms and have copies ready when you go to the courthouse to formally file your complaint. So be prepared. Going to the courthouse and asking for copies is not going to end well. They will say, no, there's no copier or any system for that. So be prepared and come with at least 3 copies of everything on the day that you decide to file. You also need to find a notary public. Law firms have them. Courthouses do not most of the time. Other places that have them include banks, and UPS also has notaries. So you'll need to find one in the community. There are a few of the forms you need to file must be notarized. Many of the forms do not need notaries, but some of them do. Then, of course, you will need to find the closest post office because you're going to have to serve all of these forms on the other party, on your spouse. In Wake County, the post office is actually attached and on the same building as the civil court, which is very easy. So you can walk those forms in, you can file them, and then you can walk next door and have them mailed properly. And we will talk about how to mail them shortly. Okay, we have 2 ways to file. Process number 1 is for you to simply print out all of the forms that are online at the North Carolina Courts website. It's fairly straightforward. I'm going to give you all the form numbers. All of them are fill in the blank. You can download a copy of each one and handwrite everything that needs to go in it, and then bring copies of those to the clerk. The other option now is North Carolina's guide and file. So we have a system that it was set up early last year that now allows for you to complete the majority of the paperwork online, and it will walk you through each form and help you answer each question. And you can save your information and come back at a later date or a time. Does not all need to be done at once, but it makes it quite a bit easier. If you have a computer and internet, it's a good way to go. The guide and file system actually has a short interview, and then it will allow you to simply print the forms out already completed so that you can take them and file them with the clerk. Printing out the forms and doing them paper is not as loved anymore. It's a lot easier to use the guide and file system. They are still allowing folks that are not using attorneys to file things on paper and bring them into the clerk, but they are pushing for everyone, general public, to use this new guide and file system as much as possible to streamline and simplify everything. Here is the website for guide and file that will walk you through the steps. You can get started fairly easily. It's wonderful. It's great. So the alternative, as we said, was downloading the forms. So I want to just walk through each of the forms with you. I'm going to put them all up here. Okay. So there are 4 primary forms that you need to cover. The first form is the complaint itself. You can find a complaint for absolute divorce online. You can find it on our website, and it is a fill in the blank form. It's going to ask you a handful of questions. It's going to want to know which county in North Carolina you live in, which county your spouse lives in, how long each of you have been living there. It's going to want to know the date that you were married to each other and the date that you separated and began living under separate roofs. So it's going to want to know that exact date. It doesn't have to be perfect if the two of you agree on it, and sometimes it is hard to identify or determine that exact date when the separation occurred, but it just has to be more than 365 nights. It will also ask you if you intended for this separation to be permanent, if after these 365 nights you want to have a divorce from the other party. And then it's going to ask you if there are children born of the marriage. So you're going to want to list their names and dates of birth. And finally, at the bottom, you are going to sign it and date it. And it's also going to allow you to request that you get your formal name back. So if you want to return to your maiden name, it is going to give you the option of checking a box and allowing you to write out your maiden name and ask the court to make that formal. The civil summons form is a 2-page form that goes on top of your lawsuit, and it is sent to the other party. It's going to simply ask for your address and their address. That's pretty much it. And if you go to the North Carolina Judicial website, you can type in this AOC CV 100 and the exact form is going to pop up, and you can either print it out and fill it out or fill it out online through guide and file. It's there to tell the other person, hey, you're being sued and you now have 30 days to respond if you disagree with this. So the civil summons, you're just going to need your address and their address. The domestic civil action sheet is another cover sheet that's going to ask for your addresses, and it's going to have you check a box that you're suing for absolute divorce. It's very straightforward. You are going to check a box that says, I'm filing a complaint and a box that says divorce. You'll sign and date on the bottom of this form, and you'll also bring this in to file with the clerk or do it through Guide and File. And there is a Civil Service Members Civil Relief Act form. This is that separate step if you have a spouse active or inactive military. If this person is active military, this form is going to give you specific, precise instructions on how to ensure that you can show the judge they're not somewhere else, that they are not deployed on the other side of the world. It has the directions spelled out at the front of the form on what you need to do. If this is not an issue, if your spouse has never been in the military, then all you're obligated to do is simply write out, I have been married to my spouse for X amount of years, and they have never discussed the military, nor do I have any knowledge of that they've been in the military. That is it. That's simply an affidavit that you have to produce to the judge so the judge can make sure that the other party can actually be there if they want to be there. Your spouse doesn't necessarily have to come to the court hearing, but courts need to make sure that they have that opportunity should they want to. So these forms, you can just drop in to the website. There are a few more optional forms. It costs, I believe, $150 to file an absolute divorce complaint in the event that you receive TANF, food stamps, or supplemental security income. You can complete AOCG 106 and ask the court to waive that $150 cost, and they will do so. This petition needs to be notarized. This complaint needs to be notarized. Those are the two primary things that you will need to sign in front of a notary. And the petition to proceed as an indigent will be filed along with everything else. The clerk will review it. And if you are in compliance, if you do receive any of those things, they will waive that cost. They will not be asking you for copies of an SSI payment or a picture of your food stamp card. They're simply asking you to complete the form and to swear to the court that the form is accurate and that you cannot pay. A second option for this, if you do not receive TANF, SSI, or food stamps, is an affidavit of indigency. And what it does is it asks you for all of your monthly bills. And it gives you a precise amount. And if you come in as obtaining or receiving less of that each month, the court will also waive. So if you're within, I think, 180% of the poverty line, the court can also waive the cost of the lawsuit. It's a little more time consuming and tedious, and the clerk is going to need to review it, but it's a way to get around that payment if you are eligible. All the different counties in the state have different little rules. So sometimes your county might have one extra form that they want filled out. The clerk can tell you that and guide you in the right direction. Each county has its own portion of the North Carolina Judicial Branch website, so you can look up the county that you intend to file in to see if there's any additional forms that need to be completed. But the big ones are here. All right, to file. Once you have filled out these 4 or 5 forms, you're going to want to bring 3 copies up to the courthouse, or if you're filing them online, you can do it that way. Some counties require lots of copies of this civil summons, this AOC CV 100. And some counties even require them to be printed on yellow paper. Wake County does not, but you might be turned away if you don't have yellow paper. So be prepared for that. Again, that form is simply your address and the defendant's address, the spouse's address. But each county has some little particular requests. So when you go to the clerk's office, you might be turned away the first time or asked to tweak something or fix something. That is one of them. You're also going to need 3 copies of complaint, the cover sheet, and the Service Member Civil Relief Act. you're also going to want at least 2 copies of the petition to proceed as an indigent. That's not something that needs to go to your spouse. It just needs to be filed with the court, and you're going to want to keep a copy for yourself. Okay, filing. Don't sign anything too early. If you sign and the notary signs and it hasn't been 365 nights that you've been separated, the case is going to be rejected. You will not be able to get a divorce. You have to make it exactly right. You got to wait until it's at least that amount of time before you do signatures. And it's the signatures that matter, not the date of filing. So if you sign it on day 364 and file it on day 367, it's going to be rejected. Always make sure you have the necessary number of copies, so the clerk's office isn't getting frustrated or you're getting turned away. The clerk is going to take copies of everything and they're going to stamp them with a date and an exact time. They're going to give you your court file number, which will be the number for anything related to your case. And they're going to give you extra copies back. The clerk is going to keep 1 copy for the court and going to hand the other 2 sets back to you. And your job is to then serve your spouse with the paperwork. So how do we serve them? There's a few different ways. Sheriff is the most reliable. It is a cost of $30 if you qualify as an indigent and your petition for indigency has been accepted. That cost is waived. All you have to do is show it to the sheriff. So in Wake County, you would file at the clerk's office and you would simply walk across the street to the sheriff's office. You would hand the sheriff a copy of each of the forms and you would ask them to simply take it and serve the defendant, your spouse, with all the paperwork. They're going to go to the address that you give. They're not going to go anywhere else. They're not able to search for the person. They're not going to, pull them over or serve them at a traffic stop. It's your obligation to give an exact address. They will go to that address repeatedly and attempt to serve them. If this person is simply not at the address, they will not be able to serve them and you're going to have to find a different way. I think the sheriff's office typically makes 3 to 4 attempts, but you're going to want to be in contact with the sheriff's office so that you know when it has been served. There is also a way to access your lawsuit through our portal system. And you can see if the sheriff's department has served the defendant. But the best option is to simply just call. You give your case number to the person and they will look it up and tell you if the sheriff has served the defendant. So sheriff is $30 and the most straightforward. Certified mail costs about $8 or $9. And you would simply go to USPS, provide the clerk with 4 of the forms and ask them to send them certified mail. Certified mail means the person has to sign for the mail to get it. So they're not going to drop it off in their mailbox. The spouse is going to need to sign a document when they pick it up or when it's handed to them by the postal worker at their home. And that is what proves that they've been properly served. You will receive a receipt with their signature on it once they have been properly served. It will come right back to your home, and that will be your proof that you have served them and they know about this lawsuit, and it will allow you to move forward. Publication is the third option for service, and it's what you do when you have no other options. You've exhausted everything. You've been searching, you've been doing public record searches, and you simply cannot find this person. It is definitely a more complex way of service, and it's costly. Publication requires that you run an advertisement in a legal paper 3 weeks in a row, and it can cost hundreds, if not thousands of dollars. So it is not, it's not the best option. You want to do sheriff or certified mail. You're really going to want to find the person because it can be so costly to publish. Remember that the defendant's spouse is required to get one copy of that complaint and one copy of that summons. That's what makes the lawsuit move forward. And there is always going to have to be hard proof that they were served. Okay, I will not go into this much further, but let me pull this up. When you serve by sheriff, it is easiest because the sheriff's office is simply going to upload when they do serve the defendant, they're going to do the work for you. They're going to take the paperwork and they're going to bring it back to court and it'll go in the file. And that will be your proof that you have served the defendant properly. That's why the sheriff's department is the most commonly used. Obviously, you're going to need to know the exact date the defendant was served because that's the only way you can move forward in the lawsuit. And that information will be uploaded by the sheriff once they do hand these documents and serve the defendant. All right, with your green card, when you're doing your certified mail, there's an additional step. You're going to need to take that receipt with the defendant's signature, and you're going to need to bring it back up to the courthouse and file it. There are some forms that the clerk will ask you to fill out, swearing and notarizing that you did serve the defendant and that the proof is this green certified mail receipt with their signature on it. So you're going to need to be on the lookout for that, and you're going to need to bring it up to the clerk's office and file it in the days after you receive it, because that will be the proof that you can move forward and get in front of a judge for your divorce. This is an affidavit of return of service. If you were to use a sheriff, they would do this for you. If you use certified mail, you will need to do this for you. It is another simple fill in the blank form. It's telling the court where you sent it to, when this defendant signed it, when you received it back. And it asks you again to sign with a notary, promising that this is all accurate and truthful information. So this will go in the court file if you decide that you want to serve the defendant via certified mail. Acceptance of service. Maybe your spouse is waiving service. They're saying, well, you don't need to send a sheriff. You don't need to send the certified mail. Simply give it to me and I will sign a paper saying that I received it. Under many circumstances, this is effective and much easier to deal with. In the event that they simply want to accept the documents, they're going to need to sign something saying that they did so accept. So they will sign this acceptance of service form in which they will notarize stating, hey, I didn't ask them to send a sheriff. I didn't ask them to send certified mail. I am just taking it and accepting it by hand or by mail, whatever form, but the spouse is going to need to sign off on it. Once they do, this will be uploaded to the file. You're going to need to bring this to the clerk of court. This will be your proof of service. Publication. As I stated, this is sort of a last resort. You're going to need to attempt a lot of different ways of service before you go in this direction. You can look up DMV records, you can contact family and friends, internet searches, Facebook. Some folks use private investigators to figure out where the other person is living. But it's the most costly and most challenging form. So please try to exhaust every other option before you attempt this route. Also, you should contact the local clerk to see if there are any requirements before you use publication. What you don't want to do is run an ad, spend $1,000, and then go to the clerk's office and realize that they're not going to accept this. So you're going to want to address it with the clerk's office before you even proceed in this route. And if you can, at least consult with an attorney, speak to them about this issue before running the advertisement, because there are rules about how the ad must be stated, what must be in it. It is complex and frustrating. All right, so you filed everything. Your spouse has been served. How do we get the divorce entered? How do we get the judge to sign off? There's a few different ways. Sorry. In the event that there are no other issues, you haven't filed a lawsuit for separation of property, alimony, spousal support, nothing. If it's just simply absolute divorce, we've lived separate and apart, we don't have any kids, we're not asking for anything, you can actually ask a clerk of court to sign off on it, and they are allowed to sign it and make it a judgment for divorce. There are forms that you'll need to check on with the clerk in your local county, but it is fairly straightforward, and you simply send a blank judgment. We're going to go over these forms. I think they are further along in here. You'll send the clerk 2 forms. The clerk will review your file. The clerk's going to make sure everything is right. Hey, is there service on the defendant? Yes. How long has it been since the defendant was served? Has the defendant been given enough time? Yes. Is everything right in the complaint? Did this person write down all the right things? Has it been 365 nights? Yes. And if everything lines up, the clerk can sign off on it for you. Another option is an uncontested testimonial divorce. So that's just a hearing where your spouse doesn't have to show up. If they're not contesting this, if they are okay with this going through, they're not in disagreement, they don't think that you guys were back together and it's not been 365 days, you're allowed to go before the court and ask the judge for an absolute divorce. And instead of the clerk looking through the whole file, the judge's job is to look through the whole file, make sure that everything is correct, and they can grant you the divorce. Each county is going to do this slightly differently. In Wake County, a lot of it can be done on WebEx. So if there is a hearing, you can chime in via WebEx and ask the judge. But you're going to need to ask your clerk's office in your particular county. You can just call the main line and ask questions, and they can give you that information. Okay, testimonial divorce. All right, how soon can you request this after you've served the defendant? You have to wait at least 30 days from the date the defendant was served before you can ask for the divorce itself. You have to give that other person time to respond. If they're going to argue about it, if they don't agree with it, they have to be given a certain amount of time to file a response with the court and potentially come to a hearing and have a judge hear from them. So on day 31, that is the date where you can contact the clerk's office and start looking to schedule this. Generally speaking, there's just a few documents that need to be signed and completed. You will ask the clerk for a particular date when you can be heard on your request for a divorce, and you will be obligated to complete a notice of hearing form, also at your clerk's office, and send it to the defendant so that the defendant knows, hey, it's been 31 days, haven't heard from you. I'm scheduling this for a hearing. It's going to now be set 3 weeks from now. It will ask that you tell them the date, the time, the location, the courtroom number. All that will be provided by the clerk's office once that 30 days has passed. Some counties have different forms, so it's going to be best to just call the clerk's office in your specific county to ask, but they're all pretty much the same and straightforward. It's fill in the blank. And they will be able to sort of guide you through it. Also, that you need to remember, you need to bring lots of copies of all the documents when you actually go to a divorce hearing. Be prepared, have copies of your complaint and your summons, your Service Member Civil Relief Act. You're also going to have a few other documents, and let me just see. Sorry, guys. I don't know why they don't have the forms in here. The judgment for absolute divorce. This is a form that you'll be able to also download off the internet. It will ask you to fill out, check the boxes that are appropriate. And once that hearing is done, the judge is going to sign this, and this is what's going to make the divorce happen. So I'm going to backtrack, but I just wanted to show you what it looked like. This is one of a few forms that you're going to need to bring with you so that once that judge has reviewed your file, they can sign off at the bottom and stamp it, and you are divorced. Sorry, guys. As I stated, there are some counties that do this online, some counties that do this every day. There's other counties that only do this on Fridays. In Wake County, divorces are on Fridays. So it may take you some time to get into court. When you request your hearing date, it's not going to be tomorrow. It's going to be a few weeks from now. You're also required to give your spouse at least 5 business days notice prior to that hearing being held. So if you request that hearing on day 31, you cannot have it on day 33. You have to have it day 37, 38, 39. You've got to let your spouse know, hey, I'm going to have a hearing on this. I'm going to ask the judge for this divorce, and here's when it's going to be. And you can come if you want, or you don't have to. But you need to give them that opportunity. If you're not giving them sufficient notice, the judge is going to send you away, and you're going to have to reschedule the hearing and wait the right amount of time. Okay, here are the documents. The judgment of absolute divorce is what I just showed you, and I'll show you again in a moment. And then there is one other form, the certificate of absolute divorce, which is and can be found in the forms section online, AOC CV 711. It is also a fill in the blank, which I will show to you in a second. That form will be taken and also placed in the file, confirming that the divorce has occurred. Some courts will ask you to bring a stamped envelope so that when that judge signs this judgment, they will sign multiple copies and you will mail that copy out to the other party. So you're going to need to bring a bunch of copies. The judgment is what you're going to mail out to your spouse. The certificate of absolute divorce, you don't have to keep. Only need one copy. It's just going to go in the court file, does not need to be mailed. The hearing itself. You are bringing multiple copies of everything. Dress business casual. Arrive on time. It's good practice to be there 15 minutes early and prepared. So when the judge walks in, you are there, comfortable, and ready to answer when they call your name. You wait for your case to be called. In Wake County on Fridays, there can be 30 or 40 different cases on a docket. And so the judge is going to just go through them one by one. And when it's your turn, they will call you up and you will be able to answer the questions and they can sign off on your divorce. The judge is going to put you under oath and they are going to take your testimony. They're going to walk you through each question. You're not going to just be up there confused. They're going to ask where you live, where the defendant lives, when that person was served, the children that you have together, and if you live separate and apart for those 365 nights. Obviously, you want to speak slowly, remain calm, be courteous to your judge. Your judgment of absolute divorce are those questions that the judge is going to ask you. So you can sit up there and honestly read through it. They will prompt you. They're not going to just let you flounder. But those are the questions that have to be answered in order for a judge to sign off on it. So we've gone over this judgment of absolute divorce. 4 copies must come with you. Judge is going to sign multiple copies and send you away with some so that you have a copy and you can send it off to the defendant. Be sure to mail a copy of the judgment of absolute divorce to the defendant and sign the certificate of service at the end of this form stating as such. You want to make sure the court knows that it was properly sent to this person and they know that you're divorced. This is that second form that you only need 1 copy of, a certificate of absolute divorce. It asks for your full name, county of residence, their full name and residence, your date of marriage, the place of your marriage, children, and the date you formally separated. You just need 1 copy. You need this filled out correctly, and you're going to hand it up to the judge when they ask for it. When this hearing occurs, the judge is going to go through and make sure you answer all the questions correctly and make sure that you're in compliance with the law. So if it's been 360 days, the judge is going to be listening for that. And they're going to have to dismiss the case if that 1 year hasn't gone by. That's what their job is to do, to make sure all of those things are in place and you can get that divorce. As I stated before, you need to send it to the defendant, especially if they're not there. They can come. They will be given a copy if they come, but if they don't come, you need to send a copy to them. Keep a copy for yourself of all of these documents that you have filed. And if your judgment is also asking for your name to be changed, you're going to want to keep some copies of these certified so that you can bring them to the DMV and other places and provide this name change to the appropriate places. All right. That is covering absolute divorce. Again, here's our phone number and our website. You can find divorce packets on our website that walk you through exactly what I did today. Fill in the blank forms. They are very helpful. Or you can go to the NC Courts website and find documents as well, fairly straightforward. So I will stop now and ask if there are any questions.
We do have a couple questions in the chat. The first one is asking if a home was purchased before the marriage and the spouse was never on the deed or the mortgage, is that home considered property of both the spouses or just the spouse who purchased the home?
That is a factual question. Generally, without knowing anything else, it could be considered separate property, but there's going to be other questions that an attorney would want to know before saying that this is definitely property that is only one person's and not the other's. It can change. You can buy a house and it can become marital property after being separate property. And it's going to be highly dependent on your specific facts and what is going on in your specific marriage. So I can't answer that easily.
Gotcha. No worries. If someone has an address through an address confidentiality program, can they use that address on legal documents instead of their physical address?
You can definitely use the PO box on all the legal documents, but when you're sending it certified mail, there's a separate process that you need to go through in order to get it to them. And it goes through, I believe, the Attorney General's office. You can find guidance for it on NC Courts website, but you do have to take an extra step because in order to have them sign for it, you can't just send it certified because it just goes into a PO box. So I would consult an attorney about that because it can be very challenging to get service under those circumstances.
Got you. If a child is over 18 and no longer lives with either parent, do they still need to be on the paperwork as a child that was part of the marriage?
Children born of the marriage, you can list. It won't have any impact, but if there were children born of the marriage, I would list them all out, whether they're 10 or 20.
Gotcha. And if a spouse, if someone and their spouse have been separated and they haven't had any contact in the time that they've been separated, so they don't know where they live or where they work, what would be some steps they can take to get that divorce when they don't know about where they live?
Finding where they live, I mean, you're gonna have to sort of search them out. You're gonna have to ask friends and family. Obviously, there's no obligation that you continue to talk, but you're gonna wanna be able to serve them with the paperwork, and the only way to do that is to know where they're gonna be. You can have a sheriff serve folks at jobs if you know for sure this defendant is gonna be at that work, or if there's a particular place that you know they are going to be. You can send a sheriff to that address. It doesn't just have to be their home, but you're the person that's still obligated to find them. The court will not assist in that, so you've got to track them.
And the last question I'm seeing here, again, if anyone has questions, you need to type those in the Q&A box on Zoom or the comment section on Facebook, is that if the spouse lives in a neighboring state, would you use the sheriff in that state to have them served, or would you still use the
Yeah.
sheriff?
You can definitely use the sheriff in that state. It's a little bit extra steps, but you would just contact the sheriff's department in the particular county where they're living in that state, and you can ask that sheriff's department to serve them and return the paperwork back. So that is equally as good, clean way to do it. And they will, across state lines, they will do that for you.
Okay, well, I am not seeing any more questions. And give it just a second here to see if you.
Yeah.
For someone who might be looking for equitable distribution and alimony, so they know, a simple divorce might not be best, is there somewhere they can go to get guidance when they can't afford an attorney? Do you know of anything?
I don't know any easy. Those are complicated legal issues. Now, Wake County does have a legal support center, and they have folks that staff it that are there 5 days a week to answer questions for people that do not have the ability to hire an attorney. There are a lot of attorneys that work for free. They do pro bono volunteer time at this legal support center in Wake. That might be a good place to go and ask some questions that won't cost. But otherwise, it would probably require a consultation with an attorney. It doesn't necessarily mean you have to hire them, but you would at least want to speak to a private attorney about that.
And just to follow up with what Sarah just said, I have also posted a link to the North Carolina Law Referral Service where
Awesome.
someone might be able to find information for private attorneys.
Okay.
I don't know if this is something we can answer. What are the requirements to get alimony, if any? I don't know if that's something we can answer.
One spouse is the dependent and one spouse is the supporting. It's a list of factors. But you're gonna have to establish that you need the support and the other person is capable of doing it. And then you're gonna need to go through a lengthy financial discovery process with the court to show. But that is not for today.
Gotcha. And then to prove separation, are there specific like documents someone can use? Does there need to be like a utility bill in their name? Do they need to be on a leased apartment? Or what would they need to be able to show to prove that separation period?
The judge will take your word for it under oath. You don't necessarily need any hard paper evidence of a separation date. The only time you would need hard evidence is if the other spouse is contesting it. If they're saying it hasn't been 365 days, you're going to want some paperwork to show it. And that could be a lot of things. In legal aid's case, domestic violence protective order might be that date of separation, or utility bills. That's a fantastic idea. When you moved out and got your own place and you signed up and have utility bills from there, that might be an option. But if it's not contested, the other party's not showing up to argue about it, then judge is just going to take your testimony and take your word for it.
So the last two questions, these are going to be our final two questions for this session. Someone just needs some clarity. Doesn't matter what county they file the divorce in.
I mean, obviously, once you should do an a county that is easy for one of you to get to. It could be yours or it could be the spouse's.
And the last question I see, if one spouse stays in the house and the other leaves, are they allowed to change the locks, the one who stayed?
That would be dependent on a lot of different things as well.
Yeah.
Couldn't answer that.
Gotcha. All right. As I am not seeing any more questions, I'm gonna go ahead and say thank you all so much for joining us. With a special thanks to Sarah for presenting and answering all of those questions. If you would like to review anything we talked about today, we have posted a recording of today's event to our Facebook page. It will be immediately available. You can access this recording with or without a Facebook account at www.facebook.com/legalaidnc. If you would like to register for one of our other Listen and Learn presentations, such as on wills and powers of attorneys, child custody, criminal record expungement, you can do so on our website at legalaidnc.org/clinics. Thank you all so much, and I hope everyone has a great rest of their day.